Got it right there.
This is docket 256739 FH, People of the State of Michigan versus Urban Dejan Bertley. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good afternoon, Your Honor. Robert Eason on behalf of the defendant, Mr. Bertley, who was present and standing to my left.
Counsel, could you and your client please approach the podium?
Yes.
Sir, when you get through, please raise your right hand. You swear or affirm the testimony you're about to provide with the truth, whole truth, and nothing but the truth under penalty of perjury.
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you taking medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No, Your Honor.
You had no time to speak with your attorney?
Yes, Your Honor.
And I understand there's going to be a plea today?
Yes, Your Honor.
All right. Brandon, you the plea sheet.
I'm getting it here in a second, Judge.
It took plea 2 or page 2.
Okay, I need this.
Okay, I got it.
All right. Sir, I have you at the address in Atwood. Is that still current?
Yes, Your Honor.
And what you're pleading to, we'll talk here in a moment, were you on probation, parole, or bond conditions on another file
Bond, yes.
in front of me or someone else?
I have, it was for you, but I had went to court in district for this last, but it got this.
I went to court.
But it got dismissed?
Yeah,
You
I
said you
did.
went to court in district, but it was supposed to be in front of me, but it got dismissed? Is that what you said?
Yes, the case I was on bond for just got dismissed, but it was in front of you.
Okay, so are there any open files during the time of this that are still open?
No, Judge.
Okay, very good. And so I just have to ask because there could be other repercussions from that, so I need to make you aware of that. All right, so it doesn't sound like you're saying. All right, and you're a US citizen?
Yes, Your Honor.
Are you employed?
Yes, Your Honor.
What did you do?
Sir Pizza, I work for Sir Pizza Company. I make the pizza dough and deliver to the stores, every store, every day.
All right, that's a big job. Okay, what is the plea agreement?
Thank you, Your Honor. Essentially, for a successful command sentence on count 2, the people have agreed to dismiss count 1 and habitual offender 7 notice. Further, there is an agreement with regard to the defendant's sentence, and that is that he will be sentenced on a D grid in a C1 cell, which is 0 to 11 months, and that the defendant will forfeit all seized contraband.
And obviously, I haven't looked at guidelines or anything, but if it falls outside of the D grid, C1 cell, this is still the agreement.
Correct, Your Honor.
Is that full, fair, accurate, and complete?
That is correct, Your Honor.
Full, fair, accurate, and complete.
Yes, Your Honor.
All right, thank you. Counsel, you're waiving reading count 1 and habitual second.
We are. Judge.
As to count 2, thank you.
People of the state of Michigan, the Urban Berkeley, State of Michigan, County of Illinois. In the name of the people of the state of Michigan, prosecuting attorney for this county appears before the court and informs the court that at the location and date described below in count 2, on or about October 21, 2025, at 1002 Atwood, ATTWOOD Drive, Lansing, Michigan, Ingham County, the defendant did possess with intent to deliver less than 50 grams of a mixture containing the controlled substance cocaine, contrary to Michigan law. That is a felony, 20 years and or $25,000. A consecutive sentence may be imposed for any other felony conviction and done against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 2, delivery, manufacture of a controlled substance known as cocaine less than 25 grams is a felony punishable by 20 years and or $25,000, and there'll be forfeiture of the any contraband.
Yes, Your Honor.
And looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your
Did you
Honor.
understand what you read?
Yes, Your Honor.
And if you had questions, your attorney was able to answer those?
Yes, Your Honor.
Do you have any questions of this court?
No, Your Honor.
Do you understand that by pleading, you're giving up your automatic right of appeal? So first, if you decide at some point to appeal this, you will first have to ask permission of the Court of Appeals to appeal?
Yes, Your Honor.
And you understand that you're giving up your presumption of innocence and holding the people to their burden of beyond reasonable doubt?
Yes, Your Honor.
And the ability to cross-examine any witnesses and evidence and request of the court to bring any witnesses you wanted in your defense?
Yes, Your Honor.
All right, thank you. And as to count 2, controlled substance delivery, manufacture, controlled substance known as cocaine, less than 50 grams, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
Excuse me.
Did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Anyone promise you anything other than a plea agreement that caused you to plead?
No, Your Honor.
You pled of your own free will
Yes, Your Honor.
after consulting with your attorney,
Correct, Your Honor.
and you've been satisfied with the representation of your attorney.
Yes, Your Honor.
Sir, has anyone told you what I will do as sentencing other than your agreement?
No, Your Honor.
That's because I don't know, I'm not fully informed at sentencing, I'll make up my mind when I'm fully informed. Now, you have an agreement as to how sentencing will be, we talked about that in 0 to 11 months. If I did something outside of that, I would allow you to withdraw your plea in this manner and again go to the pretrial stage. However, if you violate the law or bond conditions between now and sentencing, I don't have to follow the agreement, and I don't have to allow you to withdraw your plea. Do you understand all that?
Yes, Your Honor.
All right, thank you. And do you understand, I don't know how the guidelines are gonna come out, looks like you all looked at them and you made this agreement, but if the guidelines ended up coming out lower than this, it doesn't matter, this is what your agreement is. You understand it?
Yes, Your Honor.
All right. Sir, did this offense occur on or about October 21st, 2025?
Yes, Your Honor.
In the city of Lansing County, New York State of Michigan,
Yes, Your Honor.
at a specific location known as 1002 Atwood Drive in Lansing.
Yes, Your Honor.
You did possess the controlled substance known as cocaine,
Yes, Your Honor.
and that amount of cocaine was less than 50 grams.
Yes, Your Honor.
And it's fair to say you did not have a license, permission, or special permission from authority, or special permission from any authority to have that in your possession or to sell, is that correct?
Correct, Your Honor.
And how is it you came in contact with law enforcement?
Excuse me.
How is it you came in contact with law enforcement?
It came on a raid, said they had a narcotic complaint.
I did not hear that.
Came on a raid, a house raid, said they had a narcotic complaint.
All right, and then did you allow them to enter?
As I was going over the door, they broke it down.
Okay, was there a warrant?
Yes,
Okay, so they followed the warrant as far as you understood.
yes.
And then they ended up finding the cocaine. Do you know where they found the cocaine?
From my understanding, they found it in their pants pocket of mine. Pants, sweatpants pocket.
Okay, did you place it there?
Yes.
Well, you weren't, you sort of are hedging a little bit. You weren't surprised that the cocaine was found in your pants pocket, were you?
I didn't know it was there at first, but when they told me, I just, yeah, it's mine.
Do you recall putting it in your pants? I mean,
No.
you're not suggesting there's a cocaine fairy who finds your pants and puts it in there?
No, yeah.
Okay, so you would agree with me that that cocaine ended up in those pants, whether you remember that specifically or not, by you, not someone else?
Yes, Your Honor.
And you knew that it was unlawful for you to have that cocaine, correct?
Yes, Your Honor.
All right. And on behalf of the people, any additional questions, and did it test out to be cocaine?
Yes, Your Honor.
Okay, and any additional questions?
Yes, Mr. Burley, when you were possessing the cocaine, you were possessing it with the intent to deliver it or give it to someone else?
Yes, Your Honor.
Thank you for the promotion, but that's, thank you.
Okay, one thing we hope he wears the robe. All right, and counsel, did you have any additional questions?
Nothing additional, Judge.
No, thank you. Our counsel where promises to us inducements other than those placed on the record.
No, Your Honor.
No, Judge,
Has court complied with court rule?
Yes, Your Honor.
it has, Judge.
I find that this plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, trust, coercion, or promises of leniency. I also find there is sufficient grounds to accept defendant's plea. Therefore, count 2 will enter, count 1 and the habitual second offense notice are dismissed in their entirety. If there are any outstanding warrants related to this file, those are called and dismissed. All contraband, drugs, weapons, ammunition, whatever was found at this location that was seized as contraband, is hereby forfeited. Do we have a sentencing date?
June 24th at 10 a.m.
Does that meet with your schedule, counsel?
It does, Judge.
All right, sir, today, if you could go downstairs and make an appointment with probation that you keep, they'll do a very detailed pre-sentence investigation report. If you don't have time today to do that, on the purple sheet we're going to give you, there's the phone number of probation. You'll have to call them within 24 hours and make that appointment. That number is 517-483-6100. Counsel, if you could retrieve that form and give it to your client. Yes.
I was going to pre-trial services already.
You have to go to, you continue to go to pretrial services until sentencing, but you need one appointment with probation, and they're going to interview you, they're going to do a very detailed report, and your attorney, you will talk about it before you get on the record, and we'll all talk about it at the time of sentencing, okay? If you decide not to do that, I have a standing bench warrant to be picked up, and you'll have to wait in the county jail until they get to see you. So please get that done. And it's easiest if you just go downstairs and make it now. Just go to the lower level and make that appointment, okay? All right, and you have that notice there, sir?
We do, Judge.
All right, thank you.
Thank you
That's
very
all
much.
for now.
We need David Christian next.
Could we get more copies of the pre-drop one? The last one is here. Thank you.
No, it's a pre-trial.
I don't want to take the last form. from you.
Yes, that's good.
Is this one yours?
Yep.
Yes.
These are empty, but thank you.
Let me grab it starts.
Oh, never mind, he's here.
Is your client here, or date's bringing them out?
The ring.
Yeah, no, he was here. And we got an email that said, Vitalson was gonna be covering it,
Oh, there he is.
and it was likely to leave.
Yeah, I was getting that.
Okay.
Last page. I made copies of everything but the last page.
There were two of them.
Last pages?
Yeah.
Like it.
They can beat it.
You want,
Yes.
you want 2 last pages or 1?
Actually, two of both. There are 2 things. I'm going to try and make this as quick as possible. I have a trial tomorrow, I'm tired, man.
I'm leaving that there. I don't trust him. Bart's giving me trust issues today.
get their earrings. Look at that. This is docket 26-701 FH. 26-707 FH. People of the state of Michigan versus David Lamont Christian. Counsel, your appearance for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of David Christian. Mr. Christian is present at council table. He's seated to my left.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the county perjury?
Yes, Your Honor.
Thank you. Put your hand down. We were supposed to have a couple of different things today, a criminal pretrial conference, a PA 53 bond hearing, an arraignment, and a bond hearing.
Yes, Your Honor.
Okay.
We initially come for a bond hearing on motion from the defense. The people then discovered jail calls. We then are holding a contested hearing. This is also the date of the pretrial conferences as well. I'm filling out the forms right now, but I think it would be most appropriate to just go forward with the contempt.
Okay, do I have I don't remember, and I'm sorry, I'm just going through the papers. Did I arraign him on this already?
Maybe so?
Yes.
Yes.
That's what I
Yes.
remember, but.
He was arraigned, he denied, and he wants a contested hearing.
Okay, I'm just looking for the documents, just a moment. Not well. Whatever document I ran around. In either file, huh?
What document?
I need the PA 53 violation allegation.
There was an oral one at the last hearing. Mr. Pfeiffer made an allegation that there were jail calls and you said it for today.
Okay. Oh, okay, so that's it. There's nothing in writing. It was just oral on the record. I
Yeah.
remember, I just thought we had a document as well. I do.
No, they do all start to blend together.
They do, but I do also have the bond report. Does everybody have that?
Yes.
Okay. Then let's start with the hearing.
Okay. Your Honor, the people will call Detective Stephanie Kennedy.
Good afternoon.
Good afternoon.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and I don't perjury?
I do.
Thank you. Have a seat. Put your arms on the microphone. Please state, spell your name for the record.
Stephanie Kennedy, STEPHANIE
Thank you. You have papers in front of you. Is that by stipulation of council? Do you know what those are?
I don't have any idea.
Will you please remove them?
It must be from a prior hearing.
I have no idea. Maybe somebody these are total. Thank you. All right, council, you're ready. You may proceed.
Thank you. Good afternoon, Ms. Kennedy.
Good afternoon.
Where are you currently employed?
City of Lansing Police Department,
And what is your role there?
a detective.
Now, have you been assigned to a case involving David Christian?
Yes.
What has been the primary extent of your work on that case, those cases?
Communications via in-county and Lansing Police Jail.
Is this your first time testifying about communications involving this case?
No.
What things did you discover as part of your investigation?
Most recently,
We can start at the beginning.
January 13th was the first communication. I found a jail call between Mr. Christian and the victim.
And you already testified about those communications, correct?
Correct,
At the preliminary examination?
correct,
And then the contempt hearing at the district court level as well?
correct.
Did you discover more contacts between the defendant and the victim?
Yes,
I'd like to approach what he marked as people's proposed exhibit 1. If I may, Your Honor.
You may. And then the name of the victim is that Kimberly
Shaver.
Shavers? Thank you.
Detective Kennedy, do you recognize what's just been handed to you and marked as people's proposed exhibit 1?
Yes,
How do you recognize that?
I downloaded this from the Ingham County Jail call system, or ecosystem.
What does that represent?
This represents a list of jail calls made to a specific phone number.
And why were you looking at that specific number?
So on this specific one, I located this number. There were jail calls on LPD, Smart Ecosystem.
And
Smart Ecosystem is the name of the jail phone call communication.
And that led you to believe it belonged to the protected party, Kimberly Shavers?
Correct.
Why did you believe it belonged to her?
On January 23rd, which was a hearing date for Mr. Christian, he was at LPD jail. And there was phone calls made to the victim's phone number for the report, the police report, the initial police report. And in one of those jail calls, they talk about her charging his other phone, and he gives a phone number.
And that's the phone number that was searched?
It's close.
But
The
you
last number is off by 1, but the same area code that they use in other ones, and then the same numbers besides the very last number.
Now, were all of these calls from David Christian's account in the jail?
No,
When did they stop being from David Christian's account?
Your Honor, has this exhibit even been moved to be admitted at this point?
That's a fair point. It's been a long day. I seek to move people's proposed exhibit 1 into evidence.
Any objection or right here?
Thank you, Your Honor. Yeah, I object on the grounds of lack of foundation. Thank you.
Would you like to lay further foundation?
Sure. Did you determine that these calls were between the defendant and the victim?
yes,
What, in very broad terms, led you to that determination?
the phone number.
What about the context of some of the calls?
Oh, yes, they talk about court hearings, the initial incident, and their relationship.
Thank you. And does that appear to accurately reflect the list of calls to that number from the Ingham County Jail that you found in the jail call system?
Yes,
I seek to admit it.
Any objection or voir dire?
Just briefly on whether, did you ever talk to the complaining witness yourself?
I did not.
So you weren't ever able to verify that it was in fact her actual number?
Objection to that characterization. She just detailed how she did.
You verified the numbers, correct?
Which number?
The number that it was to the victim?
The number, this number
Yes.
was heard at a jail call to the number, the call was made to the number on the report from the victim. And on that call, Mr. Christian said this number minus the last number for her to call for that number.
Any additional follow-up?
But to clarify, you never talked to the complaining witness, correct?
I did not talk to her.
So you don't know what her voice sounds like, correct?
I don't.
Right, so your foundation is relying entirely upon a number that was in the report previously, correct?
And context of calls.
Thank you, Your Honor. Nothing further. I reiterate my objection on the grounds of lack of foundation. We don't know who was on the other end of the line. Obviously, this detective never bothered to follow up and actually try to talk to whoever was on the receiving end of the calls. Thank you.
Well, tell you what, if it's found that it's somebody else, I will erase it from my brain. But meanwhile, I think we're going to hear this testimony. The burden of proof here is only preponderance, so let's get further, and if there's a mistake that's been made or something erroneous, I certainly can disregard it.
Thank you, Your Honor.
One is admitted.
Thank you. So, isn't true he stopped calling from his own account once the exam happened and you testified about the calls he found on his account?
It looks like he called and called from another person. On January 31st,
And the exam was on January 30th, correct?
correct. Actually, I'm sorry, the 30th,
Actually, what?
the 30th.
So,
His last call to her was January 20, that account number was January 29th from David Christian, and then January 30th starts from Aaron Vaughn.
Starts what?
Aaron Vaughn,
BAUGH.
another inmate's name.
And that was the afternoon, the evening of the 30th, after the exam, correct?
First call
Off Aaron Vaughn's account.
on the 30th was at. Some of these are attempts and some of them are completed.
The first attempt on Aaron Vaughn's account.
It looks like 4:45.
PM.
Yes,
So, he's calling the victim from his account. You then testify at the exam about those calls. He's held in contempt. There are added charges. And then he starts calling her off of other inmate accounts, correct?
it appears to.
Now, can you tell us a little more about the context of some of the calls? Or, let me ask you this. You listened to a call from January 31st,
Yes,
2026, correct?
correct,
After the exam,
correct,
after charges were added and he was held in contempt.
correct.
Was it clear to you from listening to that call that this was the defendant, David Christian, talking to the victim?
Yes,
What made that clear to you?
they talk about the hearing.
In detail?
Yes, my name was mentioned,
So they talked about the detail of the testimony.
correct.
And did she identify herself as the victim of that incident?
Yes,
Did he identify himself as David Christian
yes.
using those words?
They were talking about sending mail. And he said that she couldn't use her name. And then when he was giving her the address, he said, you have to put my name, David Christian, and then set a inmate number.
Thank you. I have nothing further.
Ross?
But to clarify, this alleged call was made from somebody else's account, correct?
Correct,
And you have not personally talked to Mr. Christian, correct?
correct,
So you don't know what his voice sounded like, correct?
correct,
So this call went from another inmate's account to a person who on the other end, you never called to verify who was actually on that call, correct?
correct.
Thank you. Nothing.
Follow up?
Are you basing this determination in any way, shape, or form on the
Are you
sound?
basing this?
This determination in any way, shape, or form on the sounds of their voices?
No,
It's based on the actual context and
Correct.
content,
correct.
nothing else. Oh, actually, one more question. How many calls were there?
On this paper?
Yep.
223.
Thank you.
Thank you, Lisa.
Thank you.
We could publish People Exhibit 1 to the court.
Any objection?
It's been a minute, so no objection. Ron. Thank you.
Thank you.
I have no further witnesses, Your Honor.
Any witnesses, sir?
None from the defense, Your Honor. Thank you.
Thank you. Any additional witnesses or, okay, argument?
He called her 223 times. He tried to evade detection. He'd already been caught once. Find him in contempt.
Response, final word?
Thank you, Your Honor. The defense requests that this PA 53 be dismissed this time. Prosecutor has not met the required elements here. There's too many questions about the identities of the people allegedly involved here. The call originated from another inmate's account. The detective doesn't know the sound of the voices of anybody on the alleged calls. It's just pure speculation that it was Mr. Christian and the complaining witness on this case. The detective never bothered to try to follow up with the complaining witness, never bothered to verify that that actually was her number. So the extent of her knowledge is just pure speculation, relying on some numbers that might have been provided in a report at some point, Your Honor. Thank you.
Final word.
The only confusion is on the defense side and not the actual facts of the case.
I don't think there's any confusion, and the burden on this is preponderance of the evidence and means more likely than not. And more likely than not, based on the context that the detective testified to, and the number called, same number, and using someone else to throw us off the track. Something we see all the time. It's very clear that this defendant tried to go around the system and has failed. He is in contempt.
It has to be sentenced to 93 days, on top of 93 days. He might still be serving, I don't know if he's done serving the district court's time, but he still hasn't learned his lesson, clearly.
Response?
Thank you, Your Honor. Respectfully, I think Mr. Christian's already served some time here because he completed his first sentence on the PA 53, and then, as my understanding, he should now have some credit then, because he's remanded, from what I understand, after his rank on the latest PA 53 is on top of, he was already serving sentence. So respectfully, I would just request that the contempt of court portion of this, that he be ordered and given a credit for whatever time he has served. And then I would request also that I be allowed to ask for a bond for him moving forward.
Ask for what, I'm sorry?
Ask for a bond for him moving forward once he has served his sentence, if Your Honor is inclined to order additional time. Thank you.
93 days contempt. I don't know how many days credit he has. We'll give him the days credit. And after all the time has lapsed and we see his behavior, then I might entertain a bond motion. But right now, based on this, based on public safety, lack of understanding, willful lack of understanding of the court's orders at the district court level and at this level, bond is not warranted based on safety of the public, safety of the victim, and I need to see some compliance before I entertain this motion. So this motion will be put off until after the contempt, and then we'll see what has happened.
Thank you. I will try to figure out what day he finished the district court contempt, because if it's after when we brought this up, that's when the credit will start. I want to make sure we calculate the right credit form.
Should be around March 29th, Your Honor.
Okay. So March 29th would be the last day for, that's right, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 days credit.
Okay, 93 days, 11 days credit, no early release, no tether release. He won't be released until he's in front of me again. If I choose, based on behavior and other circumstances, to release him, we do it the bond report. Now, that being said, sir, you are not allowed access to any telephones, emails, whatever. You can communicate with your attorney, your other friends and people, family can come see you. And I want to warn you that, again, contempt is 93 days and or $7,500. You don't have the $7,500. Not many people do, but you got the 93 days. I have over 200 phone calls here. If I see any more, I'm going to consider doing 93 days for every time an attempt is made, because you're not getting it.
I'm filling out the pretrial form now. I'll get Mr. Saxon to have the current offer. But one thing I do want to make clear on the record for Mr. Christian, we added witness interference charges for the contacts made prior to the exam. If we so choose, we can add more witness interference charges in each file for these new contacts as well, and they are discretionary consecutive with each other. So, not sure if we're going to do that or if we're going to work that into part of the plea, agreeing not to pursue even further witness interference charges, but I want to make that clear for him.
All right, on that form, you'll have a final pretrial date and a trial date?
Yes, I think we're looking at September 25th for the trial date,
Yes.
if that works with defense schedule.
Is there anything else we need to address?
Your Honor, apparently, Mr. Christian's been having some difficulty though, with the jail in terms of being allowed to have his visits with his family. It's my understanding that Your Honor modified his bond and did allow
He
some
can have visits with his family in person,
in person.
but not the protected party, and no messages will be sent. Otherwise, if there's messages sent through family, not only will he be held in contempt again, but he won't get any visits either.
Thank you, Your Honor. So,
I think we've all been clear. I'm not sure what you're not understanding, sir. No contact means no contact. They don't exist in your world. So stop the gamesmanship and let's get on with this. Don't you want to get on with your life?
Your Honor, I have, Your Honor, and I haven't been on the phone at all. Once you told me the last time, I've never been on the phone, Your Honor.
I got over 200 calls here, sir, and context that is only related to you. So, sir, sing a different song and tell me the truth next time you're in front of me. That's all for the record.
On the 30th, Mr. Starks, I did email our teachers working and say, no, that's correct. No phone, video, or e-message unless it's with this attorney in person is okay.
okay, thank you, yeah.
Thank you.
What was that trial date?
September 25th.
25th?
Yeah.
Okay, thank you.
Yes. I think
It's
I've got
right
it.
here, I got it.
Appreciate it.
What's the date?
September 25th, the trial.
What's the final retrial?
I didn't catch that one.
It is August 26th at 10.
Oh, it's 26th. Go right to the-
All right. Thank you.
Is this one? Mr. Holtz.
Yes, sir. Yes, Bill.
Oh, I see it. Okay. This is docket 24795 FH, People of the State of Michigan versus Jason Jamar Holtz. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Holt, present and standing to my right today.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand the court or this attorney?
No, ma'am.
Or your attorney?
No, ma'am.
No, attorney. And is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
You've had enough time to speak with your attorney?
Yes.
And sir, you pled guilty to count one, police officer assaulting, resisting, obstructing, punishable by 2 years, and retail fraud, second degree count 2, punishable by 1 year. Do you recall that?
Yes, ma'am.
All right, and Mr. Ferguson, you're here in place of Scott Nickel,
That's correct, Your Honor.
and you're here for the sentencing. Scott was here for the plea. Is that
That's correct, Your Honor.
I'm going to make that correction on the basic information sheet, the cover page, and possibly in silent. We just check, make sure it's in there. And sir, have you had enough time to read the pre-sentence investigation report?
Yes, ma'am.
Great, thank you. I don't see, oh, yes, I do. Second paragraph, second line from the bottom. I'm adding Steve Ferguson for the Sounds the same. Okay, any other corrections, additions, deletions on behalf of the people?
Yes, Your Honor. As you can see, the sentencing date, it was originally on the first PSI, November 20th of 2024. That should be changed to today's date.
I think it also needs to be changed on the pre-sentence case report that is sensitive March 18th.
Okay, so, what about the, while I'm changing these, can I also change the jail credit days?
Yes.
Yeah.
What is it now?
I still think it's 54 judge because he's under an active sentence already for a different case.
That occurred after this.
Yeah, okay.
Oh, okay, so the 54 is correct.
Yes.
Okay. Okay, I think I have all of the dates corrected. Okay. Any other corrections? Oh, yes, the instant offense.
Correct, Your Honor.
And that would be 14 and 14, so changing the sentencing date. And then I think we're good.
Yeah.
For dates, yes, Your Honor. The additional correction I have is on 13 of 14 in his criminal history.
Okay.
In attorney present, it says unknown. I do have that case in front of me, and it looks like Jacob Raleigh was the defendant's attorney on that case, so I believe that attorney present should say yes.
Change it to yes. I take it there's no objection.
No, Your Honor, I think that does track with what our records indicate as well.
Okay.
And that is all the corrections the people have to provide.
Thank you. And do we have a victim here?
We do not, Your Honor.
All right.
I do have additional
What about
changes.
guidelines?
Guidelines, so yes. So according to the update pre-sentence investigation report, PRV 7 should be scored at 20 points due to the defendant's arrest and conviction on 2 new felonies in Eaton County. So I believe PRV 7 should be scored at 20. Additionally, Your Honor, PRV 6 is currently scored at 0. However, it appears that Mr. Holtz was on probation at the time of the offense in the misdemeanor case in the 13 of 14 in his criminal history. So I believe that PRV 6 should be scored at 5 points.
Any objection to PRV 7 at 20 and 6 at 5?
None to PRV seminar, but I believe if I'm reading the report correct, on this larceny, you were given fines and costs, is that correct? And no probation, so he wouldn't have been on probation at the time he committed this offense, right?
Okay, so PRV 6 would be 0.
Like you were asking for, you know.
Let me just double check, Your Honor, the case notes that we have. I thought it said something different in our file. We have to check. Never mind. I apologize, Your Honor. I have no objection with that staying at 0.
Then the total PRV is 135.
135, correct, Your Honor. That would not change the level.
All right, let me change the basic information sheet and as to the other count.
Misdemeanor, so it's not
That's
scored.
misdemeanor doesn't score, so, okay. Correction has been made. no victim on behalf of the people, what would you like me to know?
I do have one more change, Your Honor. For the OVs.
Yeah.
OV 13 is currently scored at 0. OV 13 is in regards to a pattern of criminal behavior within the last 5 years. If you look at number 12 in his criminal history, he did plead to 2 previous counts of resisting and obstructing. Those are felony crimes. So with this being a resisting and obstructing, which is also a person crime, that would be a pattern of 3 person felonies. So I believe that OV 13 should be scored at 25.
Counsel,
No objection, Your Honor.
all right, OB 13 is 25.
That would change the total to 60. That would not change the level.
Correct,
All
Your Honor.
right, I'll change this to the base sheet. All right, changes have been made.
Thank you, Your Honor.
On behalf of the people, what would you like me to know?
Yes, Your Honor. I would agree with the recommendation from the pre-sentence case report update. Obviously, Mr. Holtz has now picked up new charges. He is now in MDOC, so I would agree with the recommendation that he be sentenced to a term of 12 to 180 months with credit for 54 days to be served consecutively with his Eaton County matter, and that the retail fraud be sentenced to 54 days jail and 54 days credit.
Okay, I don't have the update.
Oh, I can give a copy of that to you, Your Honor.
Yeah. Counsel, did you have the update?
Yes, we do. Your Honor.
Can I approach?
Yes.
Yeah.
Maybe. Got something extra in there, Bart, that you're not supposed to have?
Huh?
You got something extra in there? that-
No, I just got the 2.
All right, on behalf of the defendant,
Yes, Your Honor, Mr. Holt, obviously is remorseful for his action. He also is apologetic for missing court here, Your Honor. He did get sentenced to a very similar charge in Eaton County where they gave him prison time. He's actively serving that sentence. We understand he's set for parole in December. I know I'm a little confused by probation's recommendation, Your Honor. I understand the 12, but they're asking for 180 months, which is
I was just
10.
looking at that. That doesn't make any sense.
Right. What I would ask for, Judge, is he's gonna already be on parole in the other matter. I would ask to be given the credit for the time in this case and because there's no reason to have duplicate probation or parole or any of the additional services offered, Your Honor. I just think you give him credit for the time that he's already been in and then deal with it. It's gonna be the same set of circumstances for the other matter in Eaton County. I think it's an RNO retail fraud, so it's essentially the same circumstance, Your Honor. He does understand the ramifications of what's going on. He does have a place to stay when he gets out with one of his friends, Jose Varela here in Lansing, so he is looking to do the things necessary to turn his situation around, Your Honor. I'd ask that he be given credit for the time and continue his sentencing from the case of Eaton County.
Sir, what would you like me to know?
Your Honor, I have a letter here that I wrote. Anything. Your Honor, let me start by saying I truly do apologize for my absence, which caused time out of your day to be wasted because of my actions. I ask that this court forgives me for that. Now, I know my track record don't look good, for sure. Since my incarceration within the OC, I made a choice to seek help for my addiction in completing ASAP, an advanced substance abuse treatment program. I've learned many skills and strategies to help me in keeping my sobriety and everyone, including myself, safe. Mindset that is now geared only wanting positive desired consequences for my actions. I use these skills that I've been practicing every day. My life, my family, and my freedom depends on it. I am now back on my meds through Michigan Department of Corrections, going through my psychologist there, who I meet with once to twice a month. As I also, her name is Miss Ribby. Use my time wisely while incarcerated. I am not only a member of the church at Parnell Kingdom Minded Ministries, I'm also part of the church's leadership team. I understand how important it is for me to stay this course. It is no longer about me being irresponsible, neglectful, and reckless, but about me now being and choosing to be the best me that I know I'm able to be. I thank God for opening my eyes before it was all too late. I have new goals, a new aim for new positive friends, positive leisure time activities. I have set boundaries that are healthy and life-changing for me to keep, and for everyone around me to be safe. The criminal-minded, drug-addicted me had been lost with no aim or positive purpose. Today, I love myself. I care enough to do the right things, to make the right choices as a responsible, law-abiding citizen, even when no one but God is watching. My newfound desire and God-given purposes in life for me to be of service, of good service to others. The consequences to these services rendered are to bring me joy and also to others as well. I haven't been this peaceful in a long time. As I ask this court for my mercy, have mercy on me this day of sentencing, to run my sentences concurrent with sentences currently serving, with all due respect. Also, in dealing with my ongoing drug abuse and criminal behavior, I have been participating in RSAT, ASAP program, practicing as well as applying effective communication skills with authority figures. Of course, of all of these ARNOs that I've gathered and earned. After leaving such irrational beliefs about law enforcement, also handling social pressures by doing the right thing no matter what, I've been using new strategies like stop and think, don't get sucked in, take a deep breath, coach myself in these thoughts to keep my self-control. Another great tool is redoing irrational relief analysis, where I ponder an event, think of my belief about it, and then come up with the consequences of my old way of thinking, and then my new desired consequences. My desired consequences are to see all positive actions moving forward. I'm also, too, I've completed successfully my ASAP program. I don't know if you can take a look at this.
Yes, ma'am.
Along with the relapse prevention program. I've also earned a certificate for blood spill. So, and also as a POA, prisoner observation aide, where I watch over ones who are suicidal and or homicidal and within their BOC.
It's always interesting to me, sir. But as a free man, you couldn't find Jesus. As a jailed man, you found that he lives in the jail or the prison. It's too bad you didn't find him on the outside. It sounds like you could have done a lot of good on the outside instead of for the last 18 years terrorizing everybody. You've had 18 years where, and these are just the times you got caught, where you've been in front of judges and you've done some horrifying things to the community, to yourself, to your family. At what point are you really gonna learn? Because I have a feeling, although you've told me a lot of nice things, you've been in front of a lot of judges and you've said similar things. If this doesn't stick, you're gonna end up dying in prison. This has to stop now. So I really hope that you are putting some truth into those words. Because if you aren't, the truth will be that you're gonna be in a body bag or jail cell for the rest of your life. It doesn't get better from here unless you truly put the action behind your words. And I deal in evidence, so I want to see that evidence.
Yes.
You understand?
Yes, ma'am.
Because I look at this record and it's horrible. It's the 14th time you've been in front of a judge. And not with one offense, but with multiple offenses, some of them life offenses. And you haven't been put away for life yet, but it's coming. So I don't know what conversation in the end you're gonna have with God, but I do know what conversation you're gonna have with the judge in a row if this continues.
Yes, ma'am.
So it's now that you decide if you wanna be a jailed man, a dead man, or a free man. Because those are your choices. You limit your choices every single time you commit a crime. And I look at this file, I don't know why you got such a good deal on this. You had unarmed robbery, a 15-year felony, and you got pled down to a 2-year and a 1-year. I suspect this is the last of your good deals, especially if you're in front of me.
Yes, ma'am.
And you're way too old to do this. Jail's gotta get harder and harder, and prison's gotta get harder and harder every year you get older, doesn't it?
Yes, it does.
Well, then respect yourself enough to do good, because you know what, when you do bad things, it comes back to you 10 times. So when you do good things, it comes back to you 10 times. So decide what you want. As to count 1, police officer assaulting, resisting, obstructing, you will receive 12 months to 24 months in the Michigan Department of Corrections. As to count 2 is 54 days with credit for 54 days. And you'll pay a $50 state cost on that, a $68 state cost on count 1, and $130 crime victims. Those are non-waivable. That's a total of $248, but you don't have to pay that until you, I won't have that kick in until after you're released and out for 1 year. This sentence will run concurrent with what you're now serving. So it's not gonna make it worse for you. But to just give you credit for what you've served when you continue to do all of this and assault our police officers who save lives. When you're not there for your family, they're calling 911 and those police officers are risking their lives. And you, someone like you is going to assault them, waste their time if you don't get to save your family on time. You ever thought about that? Because the rest of us think about that. So while you are incarcerated, it sounds to me like you're doing what you need to do, but you should continue cognitive behavioral substance abuse treatment, attend trade school, and continue the good work you're doing. You have 42 days to appeal into request appellate counsel. Now you receive your appellate rights. Sir, I hope you do well, and someday come back and show me the great things you're doing. With all these things, you're certainly capable of greatness, it's just choice. The good path or the bad one. I hope it's a good one. Come back and show me.
I'll be back to show.
Good. Good luck, sir. Thank you.
Gonna do Michael Barnes next.
May I approach with the police?
That's one at 9:30. We're finally getting back to it.
All right. Nancy. All right, this is docket 25-1145 FH, People of the State of Michigan versus Michael Barnes. Before we get started, I had him as a failure to appear with a bench warrant bond forfeiture. That is now dismissed. He has appeared and will proceed. I understand there's going to be a plea today. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Bart Buxton on behalf of People of the State of Michigan.
Good afternoon, Your Honor. Excuse me, Assistant Public Defender Stephen Feidelson standing in for Mr. Etheridge, who does apologize, but he had to go to another matter in another court. On behalf of Mr. Barnes, standing to my right today.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Can you just speak up? Counsel, could you just move the microphone closer to him? Thank you. Sir, are you taking any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And have you had an opportunity to speak with Mr. Feidelson?
Yes, ma'am.
And are you a US citizen?
Yes, ma'am.
And are you, at the time of whatever you're pleading to, were you on probation, parole, or bond conditions? And another file? So you're pleading today, correct? At the time of that offense that you're pleading to, were you on bond conditions, parole, or probation on another file? All right, and are you employed? What do you do? AAA? All right. Did you graduate high school? Do you need it to do what you're doing? All right. What is the plea agreement?
Your Honor, the defendant will be pleading to count 1, carrying a concealed weapon. There will be a kill agreed agreement to no upfront jail at the time of sentencing.
Full, fair, accurate, and complete.
It is, Your Honor.
Full, fair, accurate, and complete, sir. All right. As for reading the felony information.
People of the State of Michigan versus Michael Wayne Barnes. State of Michigan, County of Hingham, in the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, weapons carrying concealed, on or about February 1st, 2025 at West Saginaw Street in North Capitol Avenue, Lansing, Michigan, 48933, Hingham County, State of Michigan. The defendant did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a 2005 tan Mercury Grand Marquis, contrary to statute. As a felony, punishable up to a maximum of 5 years and or $2,500 and mandatory forfeiture of a weapon or device. Court to order law enforcement to collect DNA identification profile sample before sentencing or disposition and not take the time of arrest and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read? Not really? Okay, so carrying a concealed weapon is a dangerous weapon. It's what you carried apparently was a pistol, whether it was concealed or otherwise in a vehicle operated or occupied by you. And it appears it was a 2005 tan Mercury Grand Marquis, and it's contrary to the laws of the state of Michigan, and it is felony punishable by 5 years or $2,500, and there's mandatory forfeiture of weapon. Do you understand that? Any questions? Huh? Car was silver? All right, let me amend this to silver. Okay.
Thank you, Your Honor.
Okay.
No objection.
All right, great. All right, they'll take care of that. And so it looks like you signed the advice of rights form? Did you read it before you signed it? Okay, and once he read it to you, if you had any questions, were you able to ask those questions of Mr. Feigelson?
I'm sorry.
You asked him what?
I asked him, but it's still a little foggy to me, but I do understand what's going on.
Okay, so why is it foggy to you?
Because honestly, I've never had a charge or anything like this.
Okay. Well, sir, you don't have to plead. You can take it to trial.
No problem. But the firearm was inside of my car and I let him know no one found it.
I can't, I'm not.
He said the gun was on the side of his car. No one found the gun. He gave it to them.
Instead of taking my gun that was registered to me and grabbing my lockbox that's inside of my trunk, he just took my gun out of my car and made it look like I was just carrying it. And when the whole purpose of this stuff was me trying to go to the other store to put my gun inside the lockbox. But I couldn't make it to there because the whole street was all the way surrounded with police and they blocked off second home. So when I went out to the store, me and my brother went one way, my brother went the other way. Both had to go around the cops to the other street. I thought, I don't know, this winter, I can't just stop. I have 22-inch rims on my car. I'm in the middle of winter ice, so I'm sliding. Wasn't not trying to stop, couldn't stop. But it's coming up on myself, one with a big Tahoe truck, and to prevent getting hit in the back because I just slid with my little car. He has more weight than I do, so I tried to get out of his way, and he hits the lights.
Okay.
So,
Sir, I understand you're upset, but here's the thing. And you certainly can have more time to talk to your attorney. The weapon, do you have a license to carry concealed?
that day, I went to.
It's a yes or no. Do you have a license?
He's in the process of getting it. I think he finished the course and was waiting for the
Okay.
certificate to come in the mail.
So he had it, he just didn't have it on him? So you're telling me you went through the course, you had it.
I was supposed to take it in, my fingerprints. He didn't believe me.
But the process wasn't complete?
No,
Okay, that's the problem, is the process wasn't complete. Okay, so,
that's why I'm so quiet right now.
okay, I understand you're upset with everyone, you're upset with yourself, you're upset with the whole situation. Best I can tell you is, we can go to trial on it and see what a jury says, if you want. You can plead, but if you are law abiding in, 5 years, you can do a set aside, get the set aside and have it cleaned off your record.
What was kind of confusing to me, because prior to this, I had this same incident. The officer took my gun. He considered it, put it in the bag, he took it, he let me know I had to come downtown, pick my gun up, off my registration and stuff, and he gave me my gun back, and I did. It was called improper placement of my firearm. I had no problem with that. But a felony from my thinking.
Well, do you want to go back and have some more conversations with the prosecutor? I mean, once you take this, there's no reason for me to withdraw the plea. Sir, if you want to talk with the lawyers and see if there's a better deal, that's fine with me. I can't get involved in deal making. But I see that you are visibly upset, and if you need another, you wanna wait until a final pretrial or whatever, and you guys look at this again, that's fine with me.
I'm willing to
It's
go
your
through
life,
it.
not mine.
Judge, you have a final pretrial set for.
I'm,
Just kind of emotional.
okay, we have two people talking at once and, I can't do that.
I just said he's kind of emotional.
I
Yeah.
was just kind of emotional because I just spent 37 years of my life being an upstanding citizen, trying to stay out of trouble. I have 3 kids with AAA, so getting this kind of puts a damper on my life.
Well.
After 37 years of being.
Judge, you have a final set in October, and I understand from speaking to Mr. Etheridge that we spoke to Mr. Buxton, who spoke to Chief Assistant Prosecutor, Ms. Matusco. And they're unwilling to do anything different than what was offered to us today.
All right, so would you like to go to trial or would you like to plead? All right, so sir, it sounds like you're not gonna have any trouble in a few years getting this set aside. You're not a lawbreaker, so do the right things and get it set aside, then we clean off your record before you know it. Is that the way you wanna go, or you wanna go to a jury?
Just pass me as fast as possible.
I can't.
You can see it. Yeah.
Pass me as fast as possible.
Okay. All right. So, sir, did you have any questions about your advice of rights of me? All right, and as to count 1, weapons carrying concealed, how do you plead? Did anyone force, threaten, or coerce you to plead? Anyone promise you anything or cause you to plead? And you pled after you spoke with your attorney and you all talked to the prosecutor and tried to resolve this and couldn't, but you've been satisfied with the recommendation from your attorney and his representation?
I'm kind of not satisfied with the prosecutor's reason for.
I understand that, but your attorney has put forth your best effort. Okay. And do you understand that by pleading, you're giving up your right to a trial, the right to have the people prove by preponderance of the evidence, the right to cross-examine witnesses and evidence, the right to put forth the defense, etc. You understand all that? You're also giving up your automatic right of appeal. Now, if you wish to appeal, you first have to ask permission of the Court of Appeals to appeal. Do you understand? Is that, you need to say something?
Yes, ma'am.
Okay, and there's a recommendation for no upfront jail. If I gave you some jail, I would allow you to withdraw your plea in this matter, we can go to the pretrial stage. Also, if you committed a crime, I don't have to honor that, and I don't have to allow you to withdraw your plea if you violate bond conditions or the law. Do you understand that as well? Has anyone told you other than the plea agreement what I'll do at sentencing? Has anyone told you what I'll do at sentencing other than the plea agreement? Because they wouldn't know, I don't make up my mind until then. Sir, did this offense occur on or about February 1st, 2025?
Yes, ma'am.
In the city of Lansing County, of England, state of Michigan?
Yes, ma'am.
At a specific location known as 2025 at West Diagonal Street and North Capitol Avenue, you came in contact with law enforcement? And you were in a vehicle known as a 2005 Silver Mercury Grand Marquis?
Yes, ma'am.
Were you the operator or passenger?
Um,
You were the driver, and law enforcement came to your vehicle, came in contact with your vehicle. Is that because of the storm or what you were explaining earlier, or they just stopped your vehicle? What?
I pulled out a closed QD.
Say that one more time for me.
I pulled out a closed QD.
Closed QE. And then they stopped you? Do you know why they stopped you?
No, I was going 10 miles an hour.
Okay. And Did they ask you to step out of the motor vehicle?
No, I actually,
Okay, and then how is it they found the, pistol?
asked me about my gun. I said, yes, I am legal, but my process, I was going to be in the process of putting my gun inside the trunk.
Okay, so you point out the pistol and then he explains circumstances and then he takes the pistol.
Yes,
And at that time, although you were working on getting a carry concealed license, you had not yet completed all the forms and fingerprints, correct? And you would agree with me that a pistol is a dangerous weapon, is that correct?
yes.
And counsel, if there's any defect in the search, is that waived?
Yes, ma'am.
Thank you. May I have the people any additional questions?
The people are satisfied, Your Honor.
Judge, I think the defense is satisfied. I'd like to ask maybe one or two questions more about
You may.
the stop. This occurred on February 1st at around 12:30 in the morning, is that correct?
Yes, sir.
And the cops said that you had failed to use a turn signal, is that correct?
Yes, sir.
And they said you didn't come to a complete stop on 2 different times, is that correct?
Yes, sir.
So that was the reason for the pullover, was the failing to use a turn signal, is that correct?
That's what he said.
You have no reason to dispute that, is that correct?
No, I know that's not why I pulled me over.
And he had asked you for officer safety if there was a firearm in the car, is that correct?
Yes, sir.
No additional. I think we're
Are
satisfied.
counsel aware of premises stress or inducements other than those placed on the record?
No, Your Honor.
No, you're right.
Ms. Clerk, will I report?
You have, Your
Go
Honor.
ahead, Your Honor.
I find defendants pleased with pretty voluntarily, knowingly, and understanding they have to influence, threats, coercion, or counsel leniency. I also find there's sufficient grounds to accept defendant's plea. Therefore, count one will enter. If there's any outstanding warrants related to this, those are called and dismissed. And the weapon is forfeited along with any ammunition. Due sentencing date.
June 24th at 10:30.
I'll let Mr. Etheridge know. I think he can make that work.
Right, and certainly to downstairs and make an appointment with probation that will do a pre-sentence investigation report. We'll talk about the time sentencing. Between now and then, if you could complete a weapon safety class, or if you already have, just present that to the court, because that will be a requirement that will shorten up any probation.
Judge, he did do a class on February 1st of last year, Killing Concealed Home Defense Fundamentals class.
Okay.
I can approve.
Remind me that it was done. I'm noting it in the file.
Do you want me to give you a copy? I have a certificate here now, if you want me to give you a copy of that.
Brian, will you please make a copy of that for my file? All right, thank you.
Do you have a copy of it?
Yeah, I got the original one.
Okay, we do not need additional copy. That's a copy for the board.
Thank you.
And just to be clear, Your Honor, the people have received that previously in emails.
All right, thank you. Good luck to you, sir. Thank you.
Yeah. It's not terrible. Not terrible.
We're close to the end, July.
No.
Close to the end.
Maybe. I got my paper. I wrote on that on my paper. June 24th at 10:30.
Okay, who's next?
We can hear Mr. White's motion. 6803, it's a forfeiture matter. So I think on the document, the police department, we got $24,277.
Okay, this is docket 2568.
What case are we doing? 256803?
Yes. 256803CF. People of the state of Michigan, Shannon Wayne prosecuting attorney and Lansing Police Department versus $124,277 US currency. Claimant, counterplainant, Dejan Thomas. Counsel, your appearances for the record.
Thank you, Your Honor. Randall Berman on behalf of plaintiff.
Toby White on behalf of claimant Thomas. She's with me at the council table.
Thank you. And your motion, counsel.
Thank you. Pretty straightforward with my pleading, but what I would like to do is to address the response that I received, if I may.
Okay.
Relative to this in-rem forfeiture and the appropriateness of who can approach the court. One, there's some notion in here that I can't sue the police department. But if one takes a look at what ex-rel means, it means on behalf of LPD. So LPD is definitely appropriate. Two, I think that this statute specifically avoids having to go through a replevin process because of the nature of the facts. But it doesn't change the fact that they're not suing money. They are seizing money and they are attempting to keep that money. So what does the money have to come here and trample up here like a cartoon and say, you know, we want to go back home to Miss Thomas, our rightful owner? So I don't even understand that. Number two in the response, there's some reference by my adding facts. I added no facts. I made one comment that the police department, you know, is in large deficit, which is not any secret. But that isn't just a fact, that's more of a commentary. Lastly, they take the money and they bundle it together. $124,000, 110 of which was found in Miss Thomas's car. Mrs. Thomas's car, by the nature of the complaint, on the four corners of the complaint, was not in the curtilage. Now, there's also the commentary on number three in the response that says that it's untimely to do this. A C8 can be brought when there is a complaint that on the face of it is incomplete. You don't get faced with a C8 and say, oh, well, my discovery is not complete. No, otherwise, Your Honor, somebody could charge anybody with the most ludicrous notions and it wouldn't be dismissed because they'd say, well, we haven't finished discovery yet. No, you have to clear the first hurdle. And in that first hurdle is stating a complaint that if everything is true in the complaint, states a valid claim. They took the money, they merged it. That was wrong in the first place. And I'm quite sure that they're going to try to rely on, its, what is it, number 5D in the response. All vehicles, you know, the extent of a warrant, okay? You know, we know the warrant doesn't go beyond the curtilage. And we know that by the facts of the complaint that the car was not in the curtilage, it was across the street, not even right in front of the house that they raided. It's down the street. Guy goes out, I'm gonna go get a nap. Why? Because she was present. Two things. One, occupant does not mean guest at the house. Occupant at law is always somebody that has some sort of interest in the property or occupies the property and thereby creates some kind of attachment to the property. This, by the way it's written, would mean that the search warrant could come right in this courtroom right now and they could search everybody's car that's in this courtroom because we are all occupants. No, we're not. We are people that are attending this and we are guests or here on work. So that's way, way too broad an interpretation of occupants. And for someone that's talking about adding facts, in number 6, it's reference of, well, we found a $20 bill from Iowa. And then we found another 20 bill from Iowa with money that was all piled together on the same desk. Well, I have a $20 bill. It might have been used at a drug buy in Iowa and put back in circulation. But more importantly than that, he's adding facts. That is not in the complaint. So his complaint falls short. You can't rely on that. That's not an issue. And I think by way, and the court rules don't exclude in rem proceeding from a C8 motion. I looked through it. I found no way that it's excluded from an in rem motion. That, Your Honor, is covered it all. They're outside of the curtilage. And I'm ready to take questions.
Let me hear from the other side.
Pardon me?
Let me hear from the other side.
Okay.
Thank you, Your Honor. First of all, the motion here is brought under MCR 2.116C8 for failure to state a claim upon which relief can be granted, but sounds more in C10 for there being no factual basis or no factual dispute other than damages. And in my response, I referenced C6, but that's a typo. So I want to admit that should read C10 in my response is what this really sounds in. And so in drafting a response, it's very difficult to respond to the allegation that there isn't a claim upon which relief can be granted without going into the facts. So that had to be developed a little bit. So I would submit to the court, just off the top, that this really is an issue of facts, and that the discovery process needs to be undergone, which I've already sent interrogatories out to Mr. White's office for his client to answer 2 weeks ago, probably, under oath, so that we can determine this. First of all, the notion of what was sued here, 2 parts. Number one, my response referenced the money, and what Mr. White has said was only in response basically to his request to sever the claimants. But there are no people to sever, it's money, which leads us then into this notion that I've lumped all the money together. So our public health code forfeiture statute states that if the forfeiture is $50,000 or more, then it has to be a judicial forfeiture, not an administrative one, which is what I normally do. And so in this case, we took all the money together and sued, quote unquote, the money in circuit court in rem under the forfeiture statute. If this court is going to allow me to parse out whose money belongs to who, or say that, well, there's $14,000 in the house and Ms. Thomas had 3 heat sealed packages and it wasn't $110,000 like counsel says, 111. One heat sealed plastic bag containing $50,000, another heat sealed bag containing $51,000. And then another one containing $10,000. And so if I'm allowed to take and do an administrative, I just think it doesn't sound well with the law. And it's a way to skirt the law, then I can just do an administrative forfeiture and seize the money that way instead of coming to court by saying, well, we're only going to do a judicial forfeiture against the $51,000 package because that one's over $50,000. But as far as the other ones, I can just take care of that administratively. So what we did, not knowing what was going on, we sued, and I understand that Ms. Thomas is only claiming the $111,000 in her car. So with that said, Your Honor, I would request that the court deny the motion. A few other things, you know, the basis of the search warrant was actually heard by way of plea earlier today. So there was a search warrant on October 21st, 2025, and Ms. Thomas and Irvin Berkeley were inside the home during the search warrant. Prior to the search warrant, and this is just an offer of proof, Your Honor, from what I understand. During the search warrant, there's surveillance, and Ms. Thomas is seen pulling up to the house with Mr. Berkeley, who pled today, waving and showing her where to park, and then they go into the house, and then the search warrant is executed when 58 grams of cocaine are found. The search warrant doesn't mention curtilage, but I've quoted the language in the search warrant that it's for all vehicles registered to or under the control of the occupants, owners, and or tenants of the property described above, if present during the execution of the search warrant. She was found in the home. So they searched the car that was present at the house or near the house that they saw her go into, and saw Mr. Berkeley directing her where to park and waving her in. The last thing I wanted to touch upon, Your Honor, which now I've somehow forgotten. No, I guess I'll leave it at that. I have one more thing, and it slips my mind, but they're saying that we filed a state of claim upon which relief can be granted. But the facts need to be developed. I would submit to the court, and it's quoted in my response brief. A motion for summary disposition under MCR 2.116CH should be granted only when the claim is so clearly unenforceable as a matter of law that no factual development could possibly justify the right of recovery. The other thing I wanted to talk about is Mr. Witt started talking about a $20 bill in Iowa. So what happened is the Lansing Police Department took all the seized money and ran it through a machine. And a $20 bill that was seized inside Mr. Berkeley's home had been used in an undercover drug operation in Iowa. One of the $20 bills found in Ms. Thomas's car also was registered for an undercover drug buy from a drug operation in Iowa. That money had been put back into circulation, but I think we can make a reasonable conclusion and inference from the fact that he's got a $20 bill in his house with the dope. She's got a $20 bill that had both been used in Iowa, right? She said that.
This one I have to object. This is not in the complaint. This motion is based on what's in the complaint. And that one, Mr. Berman thinks he can find out through some discovery. He has to have a complaint that holds water, then he can start to launch some discovery.
I
But he
think
can't just file any piece of paper and say, oh, I need discovery.
he's responding to your Iowa issue, I believe,
That's correct.
that
I'm
you
trying to-
raised, so I'm going to allow him to close the loop.
So I'm trying to make some context of what Mr. White said about $20 bills in Iowa, because I think the record needs to be further developed with regard to that. So what I'm saying is, Your Honor, is that based upon all this, and their factual allegations, search warrant doesn't apply to her, and there's a $20 bill in Iowa, it's just been in circulation. That's why we have discovered. We filed a complaint for the forfeiture of the money. We did so with the information we had at the time, because it seems to be all tied together. Discovery will take place, and if it turns out that there's a rightful claim to it, then the money will be returned, or this court will order it. So otherwise, it'll be forfeit.
Well, let me ask you both, since you both raised it, she's claiming 111,000, that means there's 13,277 that should be forfeited, because nobody's challenging that.
Correct, and so I also sent a copy of the complaint to Mr. Berkeley, who defaulted, and that default motion and check to file it is on my desk. I have to just file it. He's already defaulted. He's going to be defaulted as to that portion. I understand that they want to sever it, but there's no people to sever. But I understand they're only claiming the 111,000.
Final word?
First of all, by the complaint, the money taken from Miss Thomas's car, which was not in the curtilage, and she was not an occupant of the house, she was merely present, and there's a distinction. That money was merged. It was all put on one table. Wherever these $20 bills came from, we don't know if they came from him. I'm sorry, for him or her, or both from her or both for him. And it's Iowa money, obviously been back in circulation for quite some time. It's not that they don't know each other, but more importantly, fine, if he's got this, Your Honor, you can dismiss this action and he can write a complaint that actually states grounds, and you don't have to dismiss it with prejudice, but you could make him go file a complaint that I can answer, and then we'll see what complaint and what he's entitled to. But he's basically saying, I'm just going to throw stuff at the wall and the court will let me do it. And I don't think you should. And I think you should understand, outside the curtilage, no factual connection is in the complaint that he filed with me, parked across the street, and money all merged together. And then he files a complaint against her. Well, no, I'm just taking the money, Your Honor, because I found the money in the car of somebody who was present in the house. That's not enough. That's not enough. I think it should be dismissed, make him go do the work right. I mean, as long as we're off the paper here a little bit, he's calling me up when he first does and says, oh, you prove this, you prove that, you prove that. He hasn't even proved he illegally took the money. Thank you.
Well, it certainly sounds like there are issues of fact, and it's premature for anything to happen here, that you need discovery. I don't know if you all need to redo any complaints or not. I have this motion to sever. I'm not going to, what I'm going to do is, first of all, rule as to the $13,277. That's forfeited, no one's claiming it. You both agreed that it's not a part of this. So what is at issue and needs factual development is the $111,000. And there are facts that are in dispute. We need proofs, and this case is going to go forward. I'm denying the motion for summary disposition and leaving this in the capable hands of counsel to get discovery done. I don't know what happened with the Iowa money. I don't know if they put it together, it was found together, separate, whatever. The curtilage issue, that is a question of fact in regard to the warrant. And if it says any, person's present and the officer takes her keys and clicks it and there's her car, I would deem that is a nexus to the house and is contained within the bench warrant because it talks about persons present. There is curtilage law, but I don't think it's applicable as you are arguing it today based on what you've told me the warrant was written, how it was written. So absent further proof, I can't make a decision, and you both will need to develop your facts and we'll go to hearing. Is there anything else I need to order? There was scheduling order. What do you have? Have you received a scheduling order?
I have not received a schedule.
Okay, well, we're gonna get you one.
I need nothing else, Your Honor. Thank you. Like I said, I've already started discovery.
All right, well, if you would grab a scheduling order, we'll give you a scheduling order and we'll get this case moving. Mr. Perry,
I have an order here, it's just kind of blank. I just checked denied, and if Mr. Webb wants to look at it, he can approach me.
all right, thank you. When you're ready with that, sign it. Do we have a next? Next man.
Yep, we're gonna be handling Brown Walker next. This is for 2 o'clock. Brown Walker.
I gave schedule, I schedule.
This is docket 22583 FC, people of the state of Michigan versus Rhonda Brown, Peggy Walker. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Robert Eastern on behalf of the defendant, Ms. Rhonda Brown Walker, was present, standing to my left.
All right, thank you. May be seated. This is defendant's motion to quash a bind over. Counsel, you may proceed.
Thank you, Your Honor. This motion has a couple of parts to it. This was originally a 3-count offense. After at bind over, after preliminary examination, the district court declined to bind over on counts 1 and 2 against Ms. Brown Walker. This case is from 2022. Somewhere along the road, it looks like administratively those 2 charges were placed back as active with this court. I think that the people have stipulated to the fact that those 2 charges were not sought for bind over and should be dismissed. Which
I
leaves
thought
us,
they were dismissed. On the felony information, unless there's an amended one, has counts 1 and 2, which were very serious offenses, assault with intent to murder and felonious assault, were dismissed at preliminary examination. I've seen no amended information. Is there one?
There's not, Your Honor. We're only moving forward on count 3.
Okay, so are you moving to quash now count 3?
that's correct, Judge.
Okay, you may proceed.
As to count 3, at the preliminary examination, and just to give the court a little bit more factual basis as to what occurred, on the date in question, there was a scheduled exchange that was supposed to occur between who was originally the co-defendant in this case and the complainant. When they arrived at the location where they were supposed to do an exchange of a minor child, the defendant approached a vehicle where the complainant was to talk with her about what had occurred. The complainant then emerged from that vehicle with a bat and pursued the defendant here. In response to that, the prior co-defendant obtained a bat from his own vehicle, attempted to place himself in between the parties. At the preliminary examination, the complainant testified to swinging a bat at the both of them. From that point forward, there was a scuffle that ensued. Ms. Brown Walker at preliminary examination put forth that this was self-defense and defense of others. It was clear from the evidence provided by the prosecution, which was a video as well, that the complainant was the person who initially pursued them, who initially instigated the actual physical altercation by swinging a bat at them. There's a certain point in the scuffle where the co-defendant and the complainant are swinging bats at each other. Complainant falls. The co-defendant is able to take the bat away from her. He removes himself from the situation. When he does so, the complainant stands up and again pursues Ms. Brown Walker, who then defends herself. And essentially she won the fight is what occurred. The issue that I have is that self-defense was raised there. The prosecution did not put anything forward that would defeat the issue of self-defense. There was also testimony that there was no intent by Ms. Brown Walker. She had never had any interaction, never met this person before, the complainant before. There was no prior ill will. And all of the reaction that occurred was after the complainant exited her vehicle with a bat and pursued Ms. Brown Walker. And so for those reasons, Judge, I don't believe that the bind over was appropriate. The district court judge did not make any specific findings as it related to probable cause in relation to Ms. Brown Walker. She did do so for the co-defendant, but then just sort of summarily
did the bind over, completed the bind over on behalf of Ms. Brown Walker. And so I would ask that this court would review that information, as well as I do believe that we've got a copy of the video. I think the copy that we submitted may have been sped up. We'd ask the court to review that as well and to quash the bind over.
Thank you. Counsel?
Yes.
Does the bind over, or not bind over, I'm sorry, does the video reveal that this was self-defense or what? I haven't seen it.
And Your Honor, I can play that video for you. The people would argue that that does not show self-defense, but I can show that video to you.
Okay. Any objection, counsel?
No, Judge.
Leave. Okay, just for clarification, Your Honor, so you know where you are looking, the black vehicle that's nearby the ice machine in this video, that is the victim's vehicle, and that's where this incident occurs. And there will be a red vehicle that appears behind the vehicle. And that is the defendant and co-defendant's vehicle. So for clarification, Your Honor, the individual that just walked out of the red vehicle is the defendant, and the victim is inside of the black vehicle right now.
Okay, who is who?
I will pause again, Your Honor, it's at 54 seconds.
So who's in the red, the green?
So the red, the person in red is the defendant, Your Honor, Ms. Brown Walker. The person in green is the victim, and the person in gray is the co-defendant.
Okay.
I can
Back it
breathe.
up just a little bit.
I will back it up to around. I have to go edit it to slow it down more. So I'm playing it at 29 seconds, Your Honor. That's when you can see the defendant getting out of the vehicle. And I'm pausing at 2:21, Your Honor. That is the extent of the altercation.
Thank you.
My understanding is that was submitted with the defense's copy of this motion. I did not receive a copy of that video, but I did show the slowed down version to defense prior to playing in front of Your Honor.
That's correct.
So Your Honor, in regards to this case, obviously for a motion to quash, this is in regards to the preliminary examination, and the primary function of preliminary examination is to determine whether a felony has been committed and whether there is probable cause to believe that. This is not beyond a reasonable doubt, Your Honor. This is a probable cause standard. And when deciding the bind over, the examining magistrate may consider the weight and competency of the evidence as well as the credibility of the witnesses. However, where the evidence of the preliminary examination raises reasonable doubt in regards to the defendant's guilt, the question is properly left to the jury and bind over is required. And Your Honor, that's in People v. Honeyman, 215 Mich. App. 687, 1980. So Your Honor, in regards to the standard of review, while what it basically states under People v. Williams is that the standard of review is that the circuit court must apply in considering the motion to quash is an abuse of discretion, meaning that the result was so volatile of facts or logic that it evidences a perversity of will, defiance of judgment, or an exercise of bias and passion. And once again, under People v. Doss, it states, while the reviewing court may not agree with the findings of the district court, it may not substitute its judgment unless there has been an abuse of discretion. In regards to this case, Your Honor, we are moving forward with count 3, as I stated, the assault with intent to do great bodily harm less than murder. And looking at the Michigan Criminal Jury Instruction 17.7, there are 3 elements. The first is which the defendant tried to physically injure another person. The second is that at the time of the assault, the defendant had the ability to cause an injury, or at least believed that he or she had the ability. And third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there is injury, you may consider it evidence in deciding whether the defendant intended to cause great bodily harm. And Your Honor, as you know, great bodily harm means any physical injury that could seriously harm the health or function of the body. In regard to this case, Your Honor, the testimony from the victim in this matter, he had testified that, and just to lay some additional context, prior to this incident, there was a exchange of the child, and that they had made this decision to originally, the plan was for this child exchange to occur at the police station. However, the co-defendant, who the victim has had to be quite frank, an abusive domestic violence history, which was mentioned at the preliminary examination, she was concerned, which is why she ultimately asked for this to happen at a police station. Ultimately, and it does say in the transcript that she did come up with this second location of the Quality Dairy, and at that point, the defendant did confer. However, the victim at that point was concerned with the co-defendant's reaction to this incident. So she had arrived on scene, and as you saw in the video, Your Honor, she was there first, and then the defendant and the co-defendant arrived in a vehicle and essentially locked her in, drove in right behind her vehicle and made it so she was unable to leave, unable to drive away. The defendant, Ms. Brown Walker, then approached the victim's vehicle, and as you can see in the transcript, says, and obviously you can't see it very well in the video because of where the video is located, but Ms. Brown Walker starts slamming on the driver's side window. This concerned the victim, and the victim, as you can see in the video, took a bat and started swinging it out the window because she was concerned for her life at that time. She was concerned for her safety. At that point in time, the co-defendant leaves the vehicle, and the victim gets out to realize who this co-defendant is, because she did not originally know who this person was. She just saw an individual start slamming on her window and was not quite sure what was going on. It was at that point in time she saw the co-defendant and the co-defendant's vehicle, this person that she had an abusive history with. You then see the co-defendant get a bat and essentially walk around the vehicle, not in defense of another individual, but it almost seems as if to intimidate her. He then almost makes a lunging motion at her, and that's when she makes the first swing, Your Honor, and that's when the fight between the two of them occurs. The defendant at this time, Ms. Brown Walker, as you saw in the video, originally was not involved in this altercation between the two of them, but then decided to jump in and start attacking as well. And during this incident, Your Honor, you can actually see at around 1:03, if I can go there for just 1 second. It is at around 1:03 where, so 1:03, this is where the person in green, the victim, falls down to the ground during this altercation. And you can actually see, if I play for just a second or two, that the bats have now been taken from my victim entirely. And this is at 1:05. You can see the defendant, after the victim has been completely, all weapons are gone from her, the defendant is kicking her in the head. She testified to this, and you can see this while she is unarmed being kicked. Your Honor, I think there is a question of fact as to whether it's a self-defense or not, especially when her being completely unarmed and the defendant kicking her on the ground. I believe that shows a question of fact for a jury to decide whether this is self-defense or not. The judge, and I will say that Judge Ward did consider self-defense, but ultimately decided after reviewing this video that it was a question of fact for the jury based off the testimony and based off of what was seen in the video. So, Your Honor, I would ask that you deny the motion to quash. Thank you.
Final word, your motion.
Thank you, Judge. I'll just make a couple of responses. First of all, on this morning, what occurred was that the complainant showed up to Ms. Brown Walker's home where she had never been. She had never met this person, never seen this person. She left a 2-year-old child on the doorstep and drove away. Ms. Brown Walker and her then fiance were planning, this was New Year's Day, and they were planning on leaving town. So they called and said, hey, what's going on here? The complainant said that she needed a couple days, and so she didn't know what else to do besides drop this baby off. So the issue as to where they were going to meet up was actually an ongoing conversation because of the side of town they were on versus when they were able to get a hold of her.
Wait a minute, this baby was dropped off to 2 strangers, or was one of them the parent?
The baby was dropped off to Ms. Brown Walker's home, where at that time the co-defendant did not reside. She had never been to that home. She'd never met Ms. Brown Walker. Ms. Brown Walker had never met this person. So when they do meet up, she did testify that she came and banged on her window. I don't believe that's at all what this video shows. She approached to go ask this person, hey, what's going on? And the first thing this person does is exit the vehicle with a bat. And then we watch her move towards Ms. Brown Walker with a bat. It's not until the other individual.
How does she know where the individual is? What am I missing? She drops at the home and then she follows her to this gas station?
No, ma'am. She drops the baby at Ms. Brown Walker's home.
Yes.
And leaves.
Yes.
And she rings the doorbell. She's driving down the block when she comes to the door. There's a 2-year-old child on the doorstep. It is her fiance's 2-year-old.
Okay, so it wasn't just some strange house, it was to the fiance, okay.
Yes. So the fiance calls his prior, I don't believe
Baby mama, yeah.
Baby mama, and says, hey, what's going on? She says, oh, I need a break. I need a couple of days. And, he informs her that they have plans, they're leaving town. So they eventually decide this is the location where they're going to meet up. And so, yeah, again, Ms. Brown Walker at that point goes to talk to this woman. She's never met her. They've never had any prior issue before. She just goes to talk to her. She emerges from the car with a bat and pursues her. Let
me just stop you there,
Okay.
because I saw that, and I'm like, wait a minute, this woman's got a bat. Who drives with a bat unless they're ready for arms, right? Something's gonna happen. I get that. That part concerns me. But what then concerns me is your client also has a bat, and when she has an opportunity to withdraw and the woman's on the floor, she does not. So there's a question of fact here. How I would rule, I don't know. I need to know some more and maybe have that picture blown up. But this looks like there's an argument for self-defense. I'm sure you're gonna file that, but at a point where there's an opportunity to retreat, that doesn't happen. In fact, there's more aggression going because now the adrenaline's going and this woman's down on the floor and there's a lot of kicking and hitting going on and it's 2 against 1 now. That's a problem for me. And that's where, sir, it's, and you know it as well as I do it, and I sat in district court for 4 years, and I mean, these are tough calls, but the standard is so low. It's probable cause to believe a crime was committed and probable cause to believe defendant committed the crime. I do not believe that Judge Ward abused her discretion. I think she set it up here for all of us to figure it out, and that's what's going to happen. It'll probably go to the jury. There is a real question of fact here. There is a couple of questions that ought to go to the jury. But I do understand, and she didn't make this record, and I suspect that if she would have, or if I was in district court, I would have made the record that they may have started out as self-defense, but there was a duty to retreat when she could and she didn't. She then pursued. So I am not quashing the bind over for that reason. Thank you. I appreciate your time and playing that for me and answering my questions. I do have a question asked to the child. Was CPS called in? How a mom could just drop the kid off like that? That's a problem for me. Was CPS called in?
I believe CPS was involved, Your Honor.
All right, we need to make sure of that because I want to make sure this child is not in jeopardy in any way.
And I will say, if you continue to watch that video, Your Honor, the co-defendant does take the child, put it inside of the victim's vehicle, and then drives off.
Well, this child should not have been exposed to this, shouldn't have
I would
parents to
agree.
do this, and mom shouldn't just willy-nilly drop a 2-year-old off without coordinating. So I have some real concerns over mom's behavior and perhaps dad's is putting it in the vehicle. So that's an issue for CPS, and I'm hoping that you take whatever you've got and send it over to CPS and see what they'll do, if anything. I don't know what they do these days.
Will do, Your Honor.
Thank you.
Thank you, Judge.
Do you have a pretrial stat, or what do you have? What's the next date on this?
Yes, Your Honor. There are new dates set. I know that there is a trial date set for May 22nd, I believe. I believe there is a final pretrial. Yeah, there is a final pretrial on April 29th and a jury trial on, let me see. Oh, I apologize. I think it's actually, where is it?
I just want to make sure my staff has it and everybody's aware.
No, and I agree, Your Honor.
You have those dates, sir? So the final pretrial is April 29th, and then there's a May trial date?
I apologize. The final pretrial is May 6th and the jury trial is May 22nd.
Okay, and you've already had a pretrial? Or
We've
no?
already had a pretrial, which is when we set that final pretrial and jury trial date.
Okay, what time is the jury trial's at 9? What time's the final pretrial? Do you have that?
I do not have that, Your Honor. I
Well-
believe it's at 9:30, but I don't know that.
Your Honor.
Yep.
I have the final pre-trials May 4th. The May
Oh.
6th date was scheduled in error
Okay.
Okay, May 4th
at 10 a.m.
at 10 a.m. Great, glad
Thank
we
you.
asked. All right, thank you. All right, finding my conditions are continued. Thank you. Who's preparing the order?
I can
Okay,
prepare the order, Your Honor.
great, thank you. All right, what else do we have left for today?
I believe that is it, Your Honor.
What happened with Matthew Martin?
Huh?
What happened with Matthew Martin?
Look, we have a plea. So we have the plea. We're gonna get an order for reassignment and get it sent over to drug court.
Feels like it's 6 p.m.
I know.
And what about, did we do Thomas?
Thomas had to get adjourned because Attorney Milks was sick and the defendant wanted Attorney Milks to
Do
be
we have a
his
due date?
attorney. Yes, it is, I have it written down right here. May 4th at 10 o'clock.
We did like 10 days more.
Right, that's what it is. It feels like it's 10 PM. Like 6 PM. It feels like it's 6. Feels like it's 6 PM. I have soccer practice to coach tonight. Yeah. We were out there Tuesday and it was 32 degrees. And we were out there practicing. And this poor kid, his dad didn't come to pick him up until a half hour after practice today. And he's a new kid this year, so he doesn't really know me. And I asked him if he wanted to wait in my car because he's in shorts and a t-shirt.
Oh, sweaty probably.
And he refused to wait in my car because he didn't really know me that well. And then I was the only one in the parking lot. I waited for a half hour before his dad found me.
Did you give me your jacket?
No. I didn't even think about that. I didn't have a coat. All I had was a hoodie on. Because I grossly underprepared for how cold it was.
That's why you keep extra blankets.
It was grossly underprepared for how cold it was. I was not, I was like, man, it is way